So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today we're going to be talking about a new ruling that came out of the Fifth Circuit Court, specifically around LGBTQ rights in the workplace. And this is coming from the law firm Phelps, and the author is Feedman. You can take a look at the link down below if you want to read more about it. This lawsuit was two Texas-based employers. One was Bear Creek Bible Church, and the other one was Braidwood Management. Braidwood operates a bunch of health-related businesses that operate as quote-unquote Christian businesses. They won't employ individuals who engage in behavior that the owner considers sexually immoral or gender non-conforming. And Braidwood also doesn't recognize homosexual marriage. So it's obviously a religious setup. And they sued the EEOC in 2018, looking to make the point that Title VII and under the Civil Rights Act, as well as the EEOC, violated their religious freedom. And there's a lot of backstory to this, and I will go ahead and talk about what that backstory is. So religious groups, specifically churches, are able to discriminate based on bona fide occupational qualifications, or BFOQ. BFOQs provide an exemption for the churches that allows them to discriminate specifically around the world of religion. So, for example, if there is a Baptist church that is looking for a new pastor, they can legally discriminate against a Catholic person, right? And that's sort of the nature of what the BFOQs are. I mean, they're a lot broader application, and I'm really being reductive, but that's a good overview of what they entail. And so this all goes back to Bostock versus Clayton County. And it's a little frustrating when people think that we have a biased Supreme Court. It certainly has its biases, right? Everyone does, but it's not sort of uniform. So in Bostock versus Clayton County, what's considered to be a conservative court ruled 6-3 with regard in favor of rights for transgender. And so what happened was that the plaintiff, Gerald Bostock, was fired from his county job after he expressed interest in a gay softball league at work. And so the lower courts followed the 11th Circuit past precedents that Title VII of the Civil Rights Act did not cover employment discrimination based on sexual orientation. But the Supreme Court ultimately ruled that 6-3, that discrimination on the basis of sexual orientation or gender identity is discrimination because of sex. Neil Gorsuch penned the majority opinion. So it seems very sort of short-sighted to argue that we have a particularly conservative or liberal court. This is a court that simply seems to read the laws and apply them appropriately. But so go to so in 2020 the Bostock ruling had been pushed through, and the EEOC was interpreting statutory prohibitions on sex discrimination to include sexual orientation and gender identity. So when it got to the Fifth Circuit, the Supreme Court didn't really address how religious liberties would be affected by the ruling. And so they weren't certain what was going to happen. And the Fifth Circuit discounted the EEOC's argument that the businesses lacked standing to bring their action because the EEOC had not yet taken any action against them. So what's happening here is that the Bear Creek and Braidwood are preemptively testing this in front of the Fifth Circuit Court and the EEOC. And it's kind of a political move, but it does hang over them, right? I mean, because they're uncertain of the law and how it presents itself in their daily lives, they need to test the EEOC and they need to test the courts to be certain where they stand and who they can hire and who they cannot hire. So the U.S. Court of Appeals and the Supreme Court for the Fifth Circuit ruled that religious for-profit employers are exempt from the anti-discrimination protections provided to homosexual and transgender employees under Title VII. So on my end, it's a little bit hard. I think it's important to protect both rights here, right? But I struggle with this in many ways because if there was another employer who was discriminating for religious reasons, and this was also something someone couldn't control, like their race or the color of their skin, and this was somehow related to their religious practice, could they still discriminate? And I don't know that I feel great about that. I think that that is a terrible precedence. Um, but on the flip side, should a business hire someone that they are be able to hire and be forced to hire someone that they don't actually agree with respect to their circumstances in life and the things that they are born with? I don't like that either. It's a really difficult one. It's one that I think that, unfortunately, there are no good answers to, because either way you're sort of enforcing your beliefs on another person. I think that's tough. But let me know what you think in the comments down below. Like, share, and subscribe, and we'll see you on the next video. Bye, guys.